Thank you, Thibaut, and thank you all the people here to allow me to share some ideas with you. First of all, I think it's a great initiative. I was a couple of years ago at the University of Düsseldorf, where the Pizzo organized a Corona seminar for jury PhD studies in competition war. And he had asked me participate, and I actually thought it, but would this exist in the Netherlands? And I checked and it didn't. And then Thibaut came out of the blue with this initiative and asked me to speak here. So I'm glad to do this great initiative. Now, why is it so great? Well, for two reasons. First of all, we must say great because it reminds me of my own failure. I tried myself to write a PhD, but I stopped after 1 year. I think if I reflect on myself, I regret it now, but I was too young, too jumpy, yippy. I just didn't have the academic grit and perseverance that you need to finish a PhD. But the problem with that, I quit. I joined the offer where I stayed for maybe 8 years after that. But I always said to myself, no, it's like, and I never did. So there's one piece of advice I could give you from, only one instance of empirical research is that don't quit because you will with the idea we'll pick it up later. P.S. You will. Why is PhD research so important for us? Because you lay in many aspects the foundations of our work. So I see there are two aspects here. First of all, there is, of course, your review of the work that we do. But in many of your PhD research is groundbreaking, is laying kind of the groundwork for enforcement actions, for policy initiatives that we do. So your work inspires us to take a step further and to go to change boundaries of the work that we do. And in the same time, your work gives us critical feedback of the actions that we're taking. So I think both aspects are important. And what my idea was to do with you this is in about try to keep restricted about 15 minutes is to tell you what's on our mind. So and that may give you some clues and ideas to incorporate in your own work, to quickly review our initiatives or to push it further. But also as a as in how would I say? Well, previous speak, Mr. Muller said, reach out to institutions, reach out to other universities. That also extends to us. If there is something where you think, well, you can learn from the ACM as an agent, or that you're interested in forming a case, or you're interested in a certain thing that we do, or you want to discuss some policy initiatives, please reach out. We'll be more than that. I mean, we are just like you in the sense 850 professionals. We love their work. They want to talk about it. So there is really do not hesitate one single bit to reach out to us if you think that you can contribute in any way to your research and the work we do. So what's on our mind? And then I'll keep this short, and then I leave the floor open to all your questions related to the things that I mentioned here, but also our other. I'm here and we're disposed up until Thibaut says it's time to. So what are we working on? And I thought to break it down in a couple of words. First, basically, changing the law. As some of you may know, we have two initiatives in changing Dutch competition law that also has European aspects. That is, first, we want to extend the merger review to smaller mergers. So at the moment, we have zero thresholds in the Netherlands, and we cannot review mergers below the threshold if on caveat discussed later. So one of the initiatives is to change the merger thresholds in the sense that we ask for what we call a koolkinders. That means that mergers below the threshold
shouldn't be notified, but you should have the ability to call in a merger reload special and then review your merger wording on all person. Why? Is it if the three reasons you see that the famous are still killer acquisitions in the markets? In not only in pharma and in IT, but also in other areas. And those when those killer acquisitions are below the threshold, they will restrict competition, particularly future competition. Second, you see serial acquisitions, buy and build strategies, mainly by private equity groups, where bigger companies basically gobble up smaller companies, create eventually market power, or this could lead to market power. And thirdly, we see that there is consolidation also in niche markets, where maybe it's not in the greater scheme of things that the entire economy a big problem, but for the customers and suppliers in that particular niche market, it can be a niche. Think about very specialized insurance product. Well, we have, as you know, in the Netherlands, lots of greenhouses. Insurance for greenhouse owners is extremely important. There are only very few companies who want to do greenhouse insurance, but this is typically a niche market. And if you create such a niche market, a monopoly can lead to monopoly prices, higher prices for greenhouse owners, and therefore that could be a market where there's typical markets where a merger leading to consolidation can harm competition and can increase prices for greenhouse. So this is on the Dutch side, all-in option. Second initiative is the new competition code, the possibility for the agency to impose remedies after a market investigation where it finds that there's a restrictions that basically markets are not functioning well due to a lack of competition. This is this market studies regime that you have in UK, many other countries. By now, in many other countries, Europe have a similar structure US. So call-in and new competition tool in the Netherlands. Then at the European level, we are very much involved in the and follow-up of Regulation 1 2003. And the reason why we are interested in creating a topic that they choose to focus on is increased forms of cooperation between national and conventional firms. We see that the European Commission, DG Comp, has a lack of resources, needs to devote resources to put in the enforcement of the DMA against big tech companies, but that means that other stuff gets a bit neglected that you could be in them. And I think the national competition authorities need to step up and need to play a role here, but they lack the scale and resources to do that. And furthermore, they can only operate at the national. So what we are trying to do is if we can find a way their national competition authorities can work together and then also be able to basically function jointly as a European enforcement agency. It's typical, constitutionally, institutionally, there are a million questions that you can ask. But I get the idea behind it is for developing, and it's also something we see in the long future. I got my inspiration. You're also protection agencies are much more effective at the European level, so we can learn from what they are doing. And you also see in the banking supervision, you see that the European Central Bank with the national central banks has a very interesting enforcement model from which we can learn as competition approach. And thirdly, basically that got me inspired to kind of to push this further was when I realized a number of years ago was something that I had missed before, that the states in the United States, the state attorney generals can sue under the federal antitrust laws in federal court. And when I saw that, I thought, that's interesting. Gil, would it be possible that national competition authorities jointly would sue under European law in the European courts? And of course, this is pie in the sky, and I understand we changed the treaty probably, and it's this is a long-term project, and it is something I think we have to dream and then redream how we want to build the new European enforcement system. So this is on basically the policy and the law side. If we look at the practice, what we do in where we focus on in our enforcement actions on, look at the agreements. So basically our 101, I think focus is on computer algorithmic pricing. So we are actively trying to detect whether we can find cases where we can set some standards where there is algorithmic pricing and as a result of algorithmic price increase. So we do a big market study at the moment, both from a competition point of view, but also consumer protection point of view about what we call kind of computer-assisted pricing, automated pricing. Because what we see is both in dynamic pricing, in personalized pricing, cohesive pricing, that there are new issues that we need to tackle as competition and consumer protection agencies. So this is one area. Second area is we keep working for quite a while on the sustainability agreements. We, despite the lack of no, it's not as high on the agenda for companies as it was a number of years ago, but we still see a steady stream of companies that approach us with sustainability initiatives, where they ask us whether what they want to do collectively is in line with the competition rules, and we continue to give informal guidance to help these initiatives forth. A new area which is related to this is what we see now coming. We don't have actual cases yet, but we are starting yet the first discussions where companies come together to create, European options for example, cloud services, or for defense, or for other IT services, or for serving raw materials. What we see is that many governments and particular companies, see that they, in some strategic areas, are very dependent on sources outside Europe, and they want to reshore their supply chain to Europe. And there are companies in Europe that are able to provide these services or products, but they tend to be small. And here's a typical chicken and egg problem: is the companies, the suppliers in Europe are small, and the potential customers of these companies say, well, yeah, we cannot go to these smaller companies because they do not have the scale that we need, and they're not able to invest in the quality, so we'll stay outside. And the smaller companies in Europe say, yeah, but as long as the customers do not come, I will not be able to scale up. So it's really, this is a coordination issue that you need to close the gap. So one of the ideas that we have is that if companies want to collectively purchase from new European players, and they are afraid that this coordination of their purchasing decision will be a violation of competition rules, we will be a guidance on what they can do or what they can't. Now the first discussion will be in 2 or 3 weeks with big companies, which companies that are interested in moving part of the cloud services they're providing now from big US companies to European players. And if this succeeds, and with a major push for a European cloud-based company to scale up and create a European alternative. This is also something that we cannot do as a national competition authority upon our own necessarily. So this is where we closely liaise with other national competition authorities and with the European Commission. So this is on the agreement side. On the abuse side, our focus is very much on vendor lock-in also that mostly the IT sector, but not necessarily restricted to the IT sector, where basically we are now figuring out how to deal with the situation that at the beginning, at the contractual state, there is competition, but once a contract has been entered into, due to the vendor lock-in, there is no competition anymore. So, well, how do you look at it from a competition point of view? Do you say, well, because there was competition at the procurement stage, that's enough? Or do you say, no, if there is vendor lock-in, then basically each company that has a contract has a dominant position by itself. But both are, it's an extreme position, but it is something that we have to look into, whether we can apply 102 or perhaps 101 to this particular situation.
So vendor lock-in is high on our agenda, and was also on our agenda. We recently started.
It has to do with the fact that you do not have a call-in option, that we recently launched in a 102
investigation into a merger based on the old Continental CAN and Tower Cost doctrine. And so there is a new merger, which is actually an interesting market.
It's the market for the transport of cash, money. It's an extremely concentrated market, and high entry barriers. As you can imagine, you need special cars, special trainings, personnel, and there are only a few. There are only a few customers, so it's very difficult to enter into that market. And here we see that there is one company, allegedly done,
that acquired basically Saudi competitor. But this is typically small market, small niche market. So cash transportation it's not a huge market, but a hugely important market.
Without call-in option, we have to rely to investigate this merger based on 1-2 tower cost of conflict. On the merger side, if we look at how do we review mergers, what's high on our agendas? First, how do we review serial acquisitions? So we recently finished an investigation into a merger investigation in the pellet industry, transportation pellets, and where there was one company that acquired in a period of 4 years, I think about 15 to 20 different smaller companies. Most of them we know the threshold. One of them was about the threshold, and there we were able to lead the transaction, and we can created the conceptual framework how we would look at serial acquisitions. So not only looking at the reviewable transaction, but we said for the contextual analysis, it is important to take into the merger review all the transactions over the past. We didn't give a number, but past period, it may not have materialized yet into market power in practice. And we said we will take on board future transactions that are likely to happen. This was the conceptual framework for the analysis of this series from serial transactions. In this particular case, we cleared the transaction, which is on the one hand because we were able to set the standard. On the other hand, it's not good because it hasn't been reviewed and it will not be reviewed by a court that was covers. But the companies now know what to expect, how we replace serial acquisitions in the future. And another very interesting case to follow is a merger between the biggest newspaper publisher, DPG in the Netherlands, and KTL, which is the biggest commercial broadcaster, music broadcaster, and it would be Indian screening platform. And so you could argue that in a traditional merger analysis, there is no overlap, newspapers versus television. and there's some overlap in online use. But what we do, and I think this is the most groundbreaking or new thing, is that we include a media plurality test into our merger systems. So we review media plurality as a element parameter of quality, and what we do in our review is see whether this transaction to the FCBE to a reduction of media plurality, and as a result of that, the reduction of quality. And it's interesting how this will develop. We had the help on this is also how you see the enforcement and academia work together. We had the help of a professor, him was cannot yet disclose the name, but it will become public later as soon as the decision will be published, who helped us in getting the framework of the analysis right. So this is on mergers. Then finally, two things. Market studies, sector inquiries, or like market study leads to remedies, ipsum competition tool. It's this whole area. We see this as a very important new tool for competition. So I think that you see a movement around Europe where competition authorities used to focus. Well, in the variable days, the competition authorities were sort of quasi criminal prosecutors in the sense that they've gone after cartels and the use of dominance that were often hidden and were in the dark. Then with merger control, the investigations became more kind of things that were happening in public in broad daylight. And you see the next development, where we are now, is that we will also review just how markets are functioning, and then come up either with remedies or recommendations how markets can function better, how competition can be improved, how consumers can be better informed in order to make markets work better. And this is I think a shift in the role of competition authorities over decades. And it doesn't mean that we will leave our semi-criminal work behind us. There will always be cartels, I'm sure, and we will always need to see that companies feel that if they engage in cartel behavior, there is a chance of detection. So this is important part of PR, but also very important that we look at the big markets where there can be credible consumer harm as a result of structure of the market, legal behavior by companies, and we cannot close our eyes. So we have now this market investigation ongoing in the Aryan market. It's where we see there is a lot of interest in those postal acid safety in other countries where consumers feel that there are these drip off, where there's wide concentration in some areas, prices is tremendously, but where there is also a difficulty because the willingness to pay of consumers is very high. So you have that, you probably always said, most people are willing to spend a lot of money on the cut of million or are forced to pay a lot on their tests. And what we see is that this market has been recently discovered by private equity companies and exploits his high abilities to pay of consumers. So what can we do as a society to protect consumers against exploitation? We look at something I told already, outright pricing, so personalized pricing, dynamic pricing, and collusive pricing. We are about to launch to finish a modest study on hydrogen transport and one on competition EV charging, electric vehicle charging along highways, where there is the market structure can be improved. And finally, we will fit be a study into the budget segment of internet access. And we hope to very much be, I don't know how it is in your area, but fiber optic access is high on the agenda, but it's pretty expensive. And there's still millions of consumers in the Netherlands that have copper access with the mobile and are happy with it. It's enough for them. They're satisfied with the service that they're getting. And if they're being switched to fiber optics, suddenly the price triples. And how is that possible? Is that fair? What can you do about it? So this is something, an area that we are big. Final point, and that's kind of institutionally. So for those of you who are interested in the institutional design of competition authorities, we have a bit of a overall design in the sense that, as Thibaut already alluded to, we are competition authority, a consumer protection agency, an energy regulator, telecoms regulator, public transportation regulator, and also digital regulation. So we do the data act, the data commons, and all the other acts that are related to it. And so we are with about 850 people. But the strange thing is the only independent body is the board of 3 people. And the ministry basically seconds 850 people to us. We don't have a multi-year budget, so every year we have to go to the ministry and ask for money and hope that you get enough money to pay on the 850 people. Well, they have to pay. But so it's an awkward situation. Also the governance, in the sense we do not have supervisory board. So who governs the board? Who is the controller of the board? Where are the proper checks and balances institutionally? So that is also an area where we try to improve the governance of the institution to make it stronger against the hateful influence, but also less vulnerable to political whims, in the sense, a minister could also say, well, next year you do not get money for 850 people, but only for 5 and that will be a disaster, because how to manage that, what will happen, and that can be done overnight at this moment. This is not a healthy situation. So this is what we are working on, and maybe this is a good timing spot, and ask you whether you need to know more about one of these topics. So,
how would you see the role of the competition authority in the sort of the growth of European players? Because the whole point of competition law is to ensure equal access in the internal market, and then creating European champions, that says you have to undermine that entire province. So do you think that under regular competition law, without any additional legislation, you can do so, or the step?
There's a very topical point is that this is something that we are now basically working on, and what we say is, as a competition authorities, we should try to create European options where there are none at the moment. So, for example, Airbus is a good example. Years ago, there was no European aircraft manufacturer that could compete with both. So European aircraft manufacturers got together, backed by governments, and said we need to create a European option. And that European option became ultimately a European champion. They didn't know at that. They just wanted to have a European option. So I think what the stage we're in now, and I think where we as competition authorities can step up, is help to create European options for where there are none, or small insignificant players. As competition authorities, at least this is our opinion as the FACM. Yeah, we should create European champions by merging companies that for example, that you now in the telecom industry, killing existing competition for kind of the greater good, if there is a. So, yes, European options and fantastic if they become European champions by their own innovation, ingenuity, commercial drive, but not creating European champions by killing off competition. For example, in telecom industry, we recently launched earlier this week a statement together with other mid-sized economies, a competition of the mid-sized economies in Europe, that we warned against telecom mergers that take place within one country. And then telecoms markets are already pretty on the edge whether there's enough competition or not. It depends a little bit on the country. And then the argument is, but you have to think European. It's good, but your customers do not think, our consumers do not think European. They want a national service, their own language, with national specifics. So, yes, if you look at here, this country, Vodafone, a European player, is active in the Netherlands, but has a national offering. So we do not see for the time being that telecoms markets will be European in any way. These are typically local markets with national preferences, with national players. Yes, they can be part of the bigger European group, but still the competition takes place at the national level. And that's with most consumer markets. So if you look at energy, or if you look at groceries, that's all national markets. So I think that the idea in which we often oppose is, you competition authorities have to make the market European. That's not us. The market definition is an empirical analysis. It's what's happening. And if you look at the markets, these are national markets. So if you let in national markets the two players merge and create a merger to monopoly, it's basically a license to print money, and you will run into issues.
Thanks to Airbus, you can also fly plane without the doors pulling out. We have Giorgio. I think you have a question, Giorgio. Not anymore.
The students are
Just wanted to mention the fact that you are here, and if you're not aware of the fact that Giorgio was here with us today, you definitely should take that as an opportunity to ask him questions either for the lunch and the cocktail, because Giorgio has an amazing experience in competition law and supervising PhDs in competition law. Thank you very much for joining. David, Skep.
Well, first of all, Martijn, thank you for the insightful overview of the sheer breadth of developments at the ACM. First of all, to second your remark on reaching out to the ACM, because I did. And we had a lovely talk about in remedies, for example, which was very insightful for my research. So I can highly recommend. I've two questions, and basically they're about two new tools, so call-in option and the market investigation tool. I was wondering, how do you see it in practice? For example, the calling tool. How are you going to investigate and decide what merges to call in? Is it own investigation? Are there sort of informal notifications? I guess if it's own investigation, it takes a lot of FGE's research. And also a practical question on the market investigation tool. How we decide on the market, how we decide what to do with the market, remedies, for example. So you might first look at, can competition law solve this, or is regulation needed? So I'm just a question of practicality.
Good. So maybe in line with the kind of the development, we have a detection group in our competition team, and our detection group used to be kind of old-fashioned policemen, and people who would go to bars and to mingle with construction companies and try to get information. And most of these old policemen, few of them still there, but most of these old policemen have retired now. So we have built a new detection team with economists, with people who are very curious by nature, with behavioral psychologists, and what we ask this detection team is basically not focus on confirmations, but focus on market problems. So we use this, and we're not there yet. So it's not. So this is a development in the organization, so this same detection team will also be asked to do the detection for below the threshold mergers and for potential markets that need to be investigated within the competition. For below the threshold mergers and our call option, we asked for what is called an asymmetric turnover threshold. That means that one of the companies needs to be big. The target can be as small as turnover of 0. So that there is no turnover threshold per target, but there is a turnover threshold per company. So that means that we can focus on the bigger companies. And we can follow these bigger companies. And what we also think of is that we can tell a bigger company, listen, we'll follow you closely. So you can do two things. You can voluntarily file either mergers with us. And we have a very low threshold. What we had to have in mind, very low threshold kind of merger filing for the call to help basically, with the hi guys, I'm planning to do this, and this is the area. Ciao. And that's it. So we don't ask more. And we haven't given it the name yet. Who's like a merger, I know, or that one. So definitely so we have the detection group, we have the voluntary not filings, but voluntary notifications, and we'll have complaints. So those are the 3 areas. We think with this, we do not need extra manpower to do, because at the same time, we also ask the government to increase the merger threshold so that we reduce the number of mandatory notifications. And I think with that change, we can have a more targeted organization on the real issues rather than do formalistic merger notification reviews of mergers that mean too much of competition effort. And then the final point is we will use, we have discretionary powers to investigate mergers or leave up agreement with use dominance. And basically we look at our capacity and see what we can handle, and we focus on the things that matter most. Call-in will also be part of that discretionary power. So if we are busy with other stuff, we will not call in a case unless we see a case that will have a profound effect on the economy, and then we'll drop something or slow an investigation in other area down, call in this particular merger. So it will be a constant juggling of resources. And, you can say, okay, we'll ask for more resources. And personally, I'm pretty reluctant to do that. I think now we have in the competition group, we have about 120 people that focus on competition. I think that is for a country of our size, more or less, right? There's no magic number. I can ask for more, but the government also needs to pay for people in healthcare and in defense and in education. I have somehow the feeling, with 120, we should be able to do it. Yes, we could do with 1,200 people. We could do more, much more, but that might be probably a appropriate amount. Also because we have and we continue to encourage private enforcement in the Netherlands. At the moment, private enforcement is dominated by damage claims after the decisions of the authority. I think that is not what's good for them. It's not adding much, I think, to competition, compliance. But this is I'm okay. But we are not getting involved in full-on litigation. What we do want to get involved in is private enforcement without an administrative decision. So we are now thinking about ramping up also our big security powers, there's now the first case coming up where we will use our security powers to join in and give kind of legal input into case with courts, private enforcement, no fall on litigation. This is still testing the water, but this is something where we see we can add and create value with relatively limited input and a possible high return.
If we can take 2 more minutes of your time, then we have a question. You'll be the last.
Yeah, I'll try.
Let's be there, Dick.
I'm sorry, I may also go if you want.
This regulatory landscape is getting increasingly complex. Like you said, the role of the ACM is changing. Also, for tasks are added to the portfolios related to instruments. Do you think there is a point where an ACM's mandate would get dual?
Yeah.
And in relation to that, how does the tie with the government and potential necessary measures weigh in?
Very good question. Very topical also. So we are a very popular agency in the sense that lots of ministries ask us, okay, do this, okay, do that. So we had to set kind of a set of rules that we applied for the structure to handle these requests. Because there must be some sort of coherent package of work. So we try to keep it as quick as possible. And a couple of things that we definitely do not do. We do not want to be a supervisory agency or enforcement agency for government entities. So because that's complex, different stuff. That if the government wants us to control local governments or other central government agencies, we say, "Will." That's what's normally needed. Second, we want to control markets where there is competition. We do have sectoral regulation, energy networks, there are competition there, but otherwise, we want to be a regulator where there is competition, because that's our special. That means that can be regulated competition, but actually competition should be the aim of the market. And finally, we have the kind of a point that if there is an authority better position to do the work, let them do it. Because to keep it a bit condensed. But nevertheless, we often have very strong discussions with ministries who really want us to do it and do not understand it if we say no. And that is, you get a really strange situation where one government agency, Ministry of Economic Affairs, is trying to get money from us. And another government agency is saying, well, but isn't the money? Do you want more money? Well, we're happy to give you more money as long as we do the tax. So this is a complicated area where we have to maneuver, and also ministries are different. So you have in the ministry, you have the policy directorates, and you have the financial director. It can be one half of the ministry that says, okay, do this. Yes, we'll make sure that you have money. And then the financial director, suddenly there is no money. So I had to learn it. I do not know. I was a private practice, so this area was pretty new for me.
It didn't make me particularly confident in the functioning of the central level, but nevertheless, there are these things that sometimes too much, like what's in the sausage. And so I have a little bit, I wish I didn't know, but how I see it functions, I wonder how the country functions. It does.
All right, I think of that. I hope you also that when you started talking about concentration on the market and mergers, the room became very dark. This is AI, of course, it's all connected. but I think it's extremely valuable. You also mentioned a couple ideas for future PhD candidates right out there, especially what I never thought about, who the competition agencies coming together, pursuing mitigations as a group. So yeah, thank you so very much for being here today. Give you a good round of applause. Do real.